Good afternoon. This is the Thursday, November 1st, 2018 meeting of the Athens City Planning Commission. All members are present. A quorum has been established. Is there anyone who has the intention to speak with the Planning Commission today? Just raise your right hand. And do you solemnly swear to tell the truth to the Planning Commission as you know it?
I do.
Thank you very much. Disposition of minutes. Are there any comments about minutes, changes, whatnot, additions? And I'll make a motion to accept.
Second.
All in favor?
Aye.
All right, so the minutes have passed unanimously.
We abstained. I abstained.
Oh, one abstention. Two abstentions, I'm sorry, two abstentions. Let's see. There are no cases before the Planning Commission today. In communications, we were going to discuss the Ohio University chilled water plant. Mr. Mayor, I'll turn it over to you.
Certainly. On or about October 29th, I sent an official request to the law director, Lisa Eliason, to get an opinion on Athens City Code section 23.03.18 and the compliance under 23.03.19. And at that point, I'd like to make a motion to receive the official opinion on that section of code from the law director.
I'll second.
Oh, your show.
All in favor?
Aye.
Aye. So that would be unanimous. Did you wish to speak at this point, or did you have something? Oh, why don't you come on up if you did want to speak?
I don't want to interrupt the flow of things. If there's going to be some discussion about the legal opinion, I also have a copy of the legal opinion.
Okay.
Your preference.
I would like to have the legal opinion presented first.
Okay. Thank you. Ms. Eliason, did you care to come to the podium and give our audience an overview? I'm catching up now.
Thank you. Last week, the mayor alerted me to the fact that he may be seeking, or the Planning Commission may be seeking, an interpretation of Athens City Code 2303.19. And I presented all of you with an opinion, and I'll just give you an overview of it. Basically, what you're asking for is for me to interpret that provision, the government property exemption provision, and what procedures the Planning Commission must follow. I took a look at the Athens City Code, a historical overview of the code, and in 1969, as you can see, it was 153.28. It's now the 2303.19. And that provided government property exemptions. Buildings and grounds of the city and the county and the state and federal government shall be exempt from the regulations of the zoning code. Then in 1997, I can tell you what the code added, and it included a provision for property rented by governmental agencies for governmental purposes and leased buildings. Then, in 2003, that section was amended to clarify the responsibility of government units, and I'm at the top of, I believe, page 2, and looking at that. I looked at some language. Actually, Clerk Debbie Walker found the minutes for the amending of 2303.19, and there was some quoted language from Ed Baum talking about where authorities cannot conform to uses within the regulations, they must inform the Planning Commission in writing, outlining the nature and reasons of the nonconformance. So that language, as you can see, didn't include the leased property provisions, but it's pretty much the same, and in fact, it is the same as it is today. I took a look at some of the case law, and the leading case seems to be the Brownfield versus State of Ohio case from 1980. And in that case, the Supreme Court stated unless there's a direct grant of immunity from local zoning laws in a given instance, the condemning or landowning authority must make a reasonable attempt to comply with the zoning restrictions of the affected political subdivision. And it appears that we added that language in the 2003 version. That case was subsequently overruled on other grounds, but that reason for the overruling of that case was limited to an action for injunctive relief can be brought in the common pleas court. Later on, 1999, there was another case that cited Brownfield, and that was the Lake Tran Board of Trustees versus the City of Mentor. And that's an interesting case. And in that case, that court looked at the Brownfield case, and now I think I'm at the bottom of page 3. No, bottom of page 2. I'm sorry, I didn't number those. And that stated, in light of the Brownfield, the applicability of Brownfield, there are two further conclusions. First, we hold that the proceedings before the Mentor Planning and Zoning Commission were superfluous, and that the hearing before the commission should never have been held. In that case, basically, they also stated that it was an issue for a court to determine it as to whether or not the government property had an exemption. There's also an Attorney General case, that's from 2001, and that one basically summarized Brownfield and Lake Tran and stated the same thing. If after making a reasonable attempt to comply with the zonings, and this was a township zoning or land use restriction, the board finds compliance would frustrate or significantly hinder its use, the board may proceed with such use of property unless a court of competent jurisdiction enjoins it from so doing. So I've given you an analysis, and basically that's a summary of what I've just told you. And again, I looked at the over the years, our government property exemption, and looked at 2 court cases and an Ohio Attorney General case, and based my conclusion that in accordance with 230319, Ohio University informed the Planning Commission in writing and outlined the nature and reasons for such nonconformance. And it's my opinion that based on what our city code says, government property exemption, that there's no further inquiry that's needed. So that's my opinion.
Thank you, Law Director Eliason. I'd also, to begin with, just an errata on my part, I said 2303.18, and I also said .19, and that was the request for it was under 2303.19 for the opinion. So thank you, Law Director.
Well, I did have one question. Where it does say if after making a reasonable attempt to comply with the township's zoning, etc., would it be then up to the Planning Commission or yourself to determine that the university had in fact made a reasonable attempt at coming close to our zoning?
Well, if you look at our language of 230319, there seem to be 2 parts, and it tells the administrative authority of the governmental unit, so that would be the state, that they must make a reasonable attempt to ensure their buildings and grounds conform to the regulations of the zoning code. But then it goes on to state, when such authorities find they cannot conform to these regulations, they shall inform the Planning Commission in writing, outlining the nature of and reasons for the nonconformance. And it's as simple as that. I don't know that there's we've had this government property exemption in since at least 1969. And it just seems that the second part of that is that when the authorities find they cannot conform, they inform the Planning Commission.
Thank you. Comment from Planning Commission, Ms. Singh, or, yeah, sorry, Nancy.
Lisa, I was wondering if you looked at the ORC.
Yes.
Does it have such an exemption in the?
Well, we have it in ours.
No, I know that,
property
but
exemption.
we had several consultants through time that said ours was very generous to the institution that we were sharing space with.
And I agree, it is generous. This does provide, though, that in light of the Brownfield case and the Lake Train case, that the proper place to go for a property owner would be to take it to a court. In fact, they could go to the Common Pleas Court on a declaratory judgment action. We've never removed this from our city code.
Mr. Stone, do you have?
No.
Okay. Christie? Mr. Mayor?
I just have one clarification. At the last Planning Commission meeting, Rick Suroy's, Director of Code Enforcement, did provide to me that Athens City Code does speak to 85 decibels as still being within code. There was a section within code, and I believe it was under the nuisance party ordinance some time ago, that we did remove the 85 decibels because of loud parties, but that was very specific to a section as opposed to the way it reads throughout the rest of code. And I believe, Mr. Soroz, you came across several places within code that does speak to a maximum of 85 decibels in terms of noise in the city.
That's correct, Mayor. It is addressed primarily, though, in the nuisance section of the code.
In nuisance.
In nuisance, primarily.
Okay. Mr. Loeb, did you have any comment? Or?
Not too much, just to point out, though, that we did provide additional documentation that we received from Ohio University and a letter addressed to me on October 23rd of this year. That information is all included in your packets that Patty put together this morning. And I distributed that to the Planning Commission, I believe, in an email I sent, forwarded on October 24. So we all should have that. That's all.
Comment from the audience?
Any other comments? Did you care to?
Yes, I would.
Thank you, Ms. Lassen. Sorry, I forgot your name.
Good afternoon, everyone. Once again, my name is Jeremy Young. I'm with the law firm of Retzel and Anders in Columbus. I represent CPP Athens 1 and its affiliates, which are the property owners immediately to the south of the proposed chiller site. I have several matters that I'd like to address. First and foremost, we just heard the law director's opinion regarding what is and is not the province of this planning commission in evaluating this proposal by Ohio University. I'm going to have to respectfully disagree with the law director in part. I believe that our analysis is that the actual immunity determination as to whether or not Ohio University can proceed without conforming with the zoning code is the province of a court of law to make that determination, and not the province of this body. However, under the Brownfield case that was cited, there's a threshold showing that has to be made. And that threshold showing is that you made a reasonable attempt to comply with the zoning code. Now that threshold determination is essential in order to even proceed to the next step to be potentially eligible for immunity. And that's the decision a court has to make. But in interpreting and applying Athens' own code section on government exemption, that code section expressly requires that the government authority first make a reasonable attempt to comply with the zoning regulations. That is the piece that we are proposing that the Planning Commission has jurisdiction to satisfy itself about, that the university made an attempt to comply with the zoning code and that it was impossible for it to do so. Then, and only then, would a court then step in and say, you know what, we're going to weigh the three immunity factors under the Brownfield decision. And that's what this Lake Tran decision that's cited in the legal opinion you just received is addressed to, is the actual immunity determination, not to the threshold showing as to whether an attempt was made at compliance. So that's the first issue I wanted to address. The second issue is the Planning Commission received, I think, on or about October 23rd, a supplemental letter from the Ohio University regarding the chiller plant. Am I correct that the Planning Commission did receive that letter?
Yes.
Yes, okay. And my apologies for the late response, but we just this morning sent you all by email a copy of a response to that letter, setting forth what we believe to be the shortcomings and inaccuracies contained in that letter. And it addresses the same categories of information that were addressed in our initial letter dated October 16th. Have you received a copy of that letter?
Is this the letter dated November 1st?
Yes.
Which is today?
Today. And again, my apologies for the late, sending it so late. We only had a limited amount of time to respond for this meeting. But I did bring hard copies with me today that I'd like to hand out to the commissioners, if you permit me.
Sure, that'd be fine.
Okay.
Actually have these.
Code Director Suroy has just handed these just prior to the opening of our meeting.
Why would I have one?
I don't have them either. I think it didn't get out. You have them all?
We do need two down
copies?
here.
Okay.
Thank you.
Super, thank you. Can we get an additional copy over here?
Sure thing. If I can.
We have one. Okay, thank you.
While we read this, do you care to give our television audience, our cable audience, a synopsis of?
I'd be happy to, Mr. Chairman. And thank you to Mr. Sorois for distributing that for us on such short notice. In this letter, as you can see, it's divided into the categories that we originally talked about back on the 18th. The first issue is the site selection for the chiller plant. The October 23rd letter from Ohio University includes a startling admission, at least from a legal perspective, and that is that in evaluating potential locations for the chiller, there was no consideration given to the zoning classification for the 7 potential sites that were considered. The basis for that was that 5 of the 7 sites are zoned R3, so it was something that they considered to not be a distinguishing factor among the various locations. However, the first point on that would be under the Brownfield decision that I just referenced, and the initial determination that we believe the Planning Commission has the legal authority to make as to whether there was a reasonable attempt made to comply with the zoning code. That admission is fatal to the university's attempt to show that it made any sort of attempt to comply with the zoning regulations. How could they possibly comply with it if they did not even consider the zoning code as a factor in their site selection analysis? Notably, as their letter indicates, there are 2 sites that are not zoned R3. They don't go into greater detail in their letter. However, subsequent research that we've undertaken demonstrates that those 2 sites are the West Green plant, located permitted use under that zoning classification. Now, we've gone into great detail in our letter addressing these alternative locations and how they are perfectly viable locations, and unlike the site proposed by the university, which is what they call parking lot 50, those sites have the virtue of the chiller plant complying with zoning if it's constructed there. And in fact, the West Green plant scored higher in OU's own site selection analysis than the parking lot 50 over by the athletic fields on North McKinley Avenue did. The Ridges location similarly scored very high. It was immediately behind the parking lot 50 location in the utility master plan. So it's the next best option in the eyes of the university, using their subjective categories to rank it. That site is zoned EI, or Educational Institution Zone. Notably, one of the permissible uses under the zoning code for that zoning classification is necessary building maintenance facilities. We believe that the chiller tower would fall under that category and would be clearly a permitted use under the EI zoning classification as well. One other point that's made in the October 23rd letter from Ohio University is that certain undisclosed operational needs necessitated that they essentially abandon the site selection analysis that they did when trying to decide where to place this facility, out of a concern that they have a location on the east side of campus. Now, once again, the reason why they wanted to put it on the east side of campus is not disclosed, and it's not entirely clear what it might be. But the top scoring location in their site selection study actually was an east side location. It was the rec open space tennis bubble location. But as I indicated at the last meeting, the university, or senior staff at the university, took that location out of consideration, once again, for completely undisclosed reasons. The next issue that my client has with this proposed chiller tower is the excessive height. I don't want to go into quite as much detail on these remaining factors, but many of you were here at the last meeting, and my client, the principal of my client, Rick Margolis, got up and talked about when the River Gate apartment complex was constructed, and when it was going through the approval process. The proposal was to construct it to a height of 4.5 stories. He was denied and was required to conform to the zoning code, which is a limit of 3.5 stories. What we're asking for here is really that the standards be applied even-handedly. This is a 9-story facility that's being proposed. It simply would not be just to disallow a 4.5-story building and then allow a 9-story building. With respect to noise pollution, I encourage the committee to carefully read the letter from OU on the 23rd and read its own sound study, the Ascentec sound study. I believe that what the Planning Commission will find when it does so is that the October 23rd letter is actually misrepresenting the findings of its own sound study in an attempt to seem more reasonable than they in fact are being. So please read the study, read the Henderson Engineers Report study that was attached to our last letter on October 16th, which points out the numerous deficiencies with the Ascentec study. And the bottom line, really, on the sound study issue is that this is it's a premature, it's an incomplete study, as the study itself admits, and that further information is necessary, further fact gathering and further analysis in order to adequately assess the volume of noise that this facility is going to produce. On the architectural design issue, OU in its October 23rd letter is seeking to justify it based on the fact that it satisfies its own architectural standards. I would hazard a guess that this committee is not in the habit of allowing applicants to come before it and justify their proposals on the basis that it satisfies their own standards. This body has to apply the proper standards under the code. And once again, under the architectural design umbrella, there's an indication that following this body's meeting on the 18th, there was a presentation given to the Board of Trustees for OU regarding a potential new design, which none of us, so far as I'm aware, know what that's going to be. And the trustees are not going to be voting on whether or not to adopt that new design until January of next year. So not only is the sound study incomplete and premature, but the actual design of the structure itself is an incomplete, non-final design, which OU believes it can change unilaterally in January. The interesting thing to note about that October 18th trustees meeting, my client, Rick Margolis, as well as his colleague, Dave Anderson, actually attended that meeting, or a portion of that meeting, and heard some discussion regarding the chiller facility. And I'm not aware of whether anyone in this room was at that meeting, but it seemed as though surprisingly, the Board of Trustee members were largely unaware of a lot of the details regarding what this chiller plant is going to be and look like. Although there was one point in question that I did want to bring to the Planning Commission's attention, which is when the issue came up, one of the trustees said, this thing looks like a nuclear reactor. Who in the world would want to live next to that? Or something along those lines. It really is not something that CPP or the other property owner that addressed this body on the 18th, Mr. DeLuca, are exaggerating. The final thing I'd like to touch on really is that the issue of whether or not the chiller tower is a conforming use under the R3 zoning classification. Obviously, the university concedes in both of its letters that it is a non-conforming use. Otherwise, they would not be attempting to proceed under the government exemption provision of the code either. But there is a reference in both letters that the zoning code could be interpreted to permit the construction of the chiller in the location proposed. And I just want to briefly address and rebut the two provisions that are cited by OU as purported potential justification for constructing it in an R3 zone. The first is under section 23.04.01C of the zoning code. That is a conditional use provision under the R3 designation. However, that section only permits a conditional use to be constructed, or a facility for a conditional use to be constructed, if it's appropriately landscaped and screened. Now, landscaping and screening is an issue that has not come up at all in any of the submissions to this body. There's been no landscaping or screening plans submitted. So it's premature and inappropriate for the university to claim that it would fall into the conditional use category. The other section that OU references is section 23.03.18 of the code, which addresses essential services and permits facilities associated with essential services to be constructed even in an R3 category property. Notably, that we disagree that it qualifies as an essential service. Among other things, that section references that the facility has to service the community. Now, what we have here is not the community being benefited by this chiller tower. It's a single property owner. It's Ohio University. Now, while there's more than one building that's going to be serviced by this thing, it's hardly something that's going to help the neighborhood or the city of Athens more generally. It's for a private party. Those are all the comments that I came prepared to make. If the commission has any questions for me, I'm happy to answer.
Are there any questions? Okay. Thank you very much.
Okay,
is there anyone else in the audience who wishes to make any other comment to the commission? Okay. Open discussion then in regards to what we've heard today. Okay. So we've established that, as I understand with Ms. Lyson, that basically this is a university issue in terms of what they want to do. Am I understanding that correctly? That they have conformed as much as they could to our zoning ordinances? Okay.
As I hear the opinion of the law director, this commission doesn't have a place to act.
Okay. Let's see, does someone want to put a motion forward then? Or
I don't know that we need a motion.
do we need a motion on that?
We do not.
Okay. Okay. So we would just move ahead with Mr. Logue.
Good afternoon, Planning Commission. A few, one or two items to report this afternoon. In regards to the city's comprehensive plan update, my interns and I, we are working on, there's a couple topics that we're trying to wrap up in the next month or so. We're working very closely studying all the city's corridors. We have some information as well that the Planning Commission did a few years ago. We've taken some of that information to make sure that we're utilizing some of that research that the Planning Commissioners did several years ago as part of that. We're also looking at disabilities and autism planning, and we are we did a lot of off-campus and on-campus student engagement. We're wrapping up all of those right now. I hope to have all of the fact-finding, I guess, for lack of a better term, data collection, all of that, most of that all resolved in the next month. And then we will be basically focusing on putting together a draft plan, doing all the, looking at some recommendations. We've got so much information that people have provided and ideas and things that we think we have some good themes to coalesce around. So we'll be working on that starting roughly late November, early December, and then working on that into the beginning of 2018 or 2019. Is that true? 2019. My goal is to get a rough draft plan completed mid first quarter 2019, discussing that with the Planning Commission and City Council, giving that, putting that out for public scrutiny and feedback, and then towards the end of the first quarter of 2019, discussing the opportunity for the Planning Commission to recommend and then City Council to adopt the comprehensive plan. All that being said, the other item that may be of interest to the Planning Commission, but the Regional Planning Commission's ad hoc committee that is looking, facilitating a discussion on a zoning ordinance for the Plains. We had our second meeting last Friday. The township trustees for both the Plains or the Athens Township and Dover Township provided the ad hoc committee with maps that they consider for the purposes of our discussion, a mapped definition of what the Plains is. So we're using that as our basis. And then we are working closely with the county prosecutor's office, one of the attorneys there, to help better understand the potential paths in Ohio Revised Code for them to move forward. We have a follow-up meeting coming up, our third meeting on, I think, Friday, November 16th at 3:30 p.m. at Athens High School. That meeting is open to the public if anybody's interested. Thank you.
Thank you. Any comments for Mr. Logue? Questions? Okay. Mr. Surai?
Yes, good afternoon. Thank you, Mr. Chairman. I just have a couple, three things here. Myself and the Solid Waste Litter Control Officers will be attending a 2018 Southeast Ohio Litter Summit next week. Actually, on November 14th. This will be where the summit brings together litter stakeholders to identify litter pickup and prevention programs and available resources. And as you very well know, we have a very strong litter control program here in the city, and we take it very seriously. The second thing is the November 15th, the code office will be closed for training, and also the whole office will be going to visit the Athens Hawking Recycling Center to get a tour from them. Lastly, this is actually a letter I sent out to all landlords and tenants, and we are actually using as much social media as possible to make this situation aware. If I may, I'd like to read it. Its subject is Code Enforcement Advisory, Recent Floor Collapses in Rental Apartment. Due to the two most recent events concerning floors collapsing in apartments, we felt it was best to address this in mass email and social media. As recent as this Halloween weekend, an Athens rental house hosted a large house party in the first floor apartment in a relatively small room. It was discovered that people were jumping up and down in unison to a song, and the floor collapsed approximately 16 inches. Fortunately, this was on the first floor, and the partial crawl space caught the floor from falling an additional 7 feet into the partial basement, saving what could have resulted in numerous injuries and possible deaths. Last week, there was a similar incident at an off-campus rental unit in South Carolina after a football game. This resulted in numerous injuries. In November 2017, at a Texas University campus building, same situation. People jumping up and down in unison collapsed the floor, injuring numerous people. During fests, we have removed people from overcrowded porches, balconies, and decks, some after seeing the very floors flexing under the weight of the crowds. With the age of some of these homes, it is very possible that the jumping up and down in unison is the cause for such tragic events. Please raise awareness and explain to tenants that homes are not designed to hold large crowd events, especially those which involve massives jumping up and down on wooden floors. Thank you. That's all I have.
Yes, Mr. Mayor?
Director Stroys, I appreciate you putting that announcement out. I would like to add that we have seen in the past not such aged structures to where that has happened as well, with decks and balconies and things of that nature. So I would not wish anyone to think that the age of the home is the most vital element here. It's just the structural integrity of whatever was built to where something like this could happen. So I really do appreciate your public notice and reaching out to landlords, and I will certainly be pushing that out during my press releases as well to make sure that that is echoed from a safety standpoint.
All right. Thank you, Mayor.
Thank you very much. Is there anyone else who wishes to speak about items not covered on today's agenda from the live audience? Okay. Are any announcements, other business? Our next meeting will be November 15, 2018. With the business of the Athens City Planning Commission concluded, this meeting stands adjourned.